Thank you for joining us this morning. Beautiful late April. Still kind of looking like it's the end of the term, so that's good to see. I'm very pleased to have Michael Harvey here. Thank you very much for joining us. I very much look forward to our discussion. Before we start off, however, let me do what is customary here at the university, a land acknowledgement. We acknowledge and respect the Lekwungen, Songhees, and Esquimalt peoples, all of the territory the university stands, and the Lekwungen, the Songhees peoples, whose historical relationship with this land continues to this day. So, with this, I turn over to my esteemed colleague, Emeritus Professor
Thank you.
Science.
Thank you, Will. I'm delighted to introduce Michael Harvey to you. I suggested that it would be an opportunity for him to talk to the campus community and to get to know you and you to get to know him. He has been the Information and Privacy Commissioner of BC for what, 9 months now, around midsummer?
A year.
Sorry?
About a year.
About a year, okay. You appointed and then he came from Newfoundland, where he was Information and Privacy Commissioner of Newfoundland. He is responsible for principally the administration of the Freedom of Information and Protection of Privacy Act, which is the provincial legislation that's been in place now for since the early 90s, which covers public bodies in BC, government agencies, as well as the so-called MUSH sector, municipalities, universities, schools, and hospitals. And that involves the freedom of information and the protection of privacy. So establishing a balance between privacy rights and access and accountability rights. In addition to that, he's responsible for the Personal Information Protection Act, which is the legislation here which governs the commercial sector in BC. BC is one of the few provinces in the country that has a separate piece of legislation for our commercial sector. He's also the Registrar of Lobbyists, so we'll talk about that today. So he's an independent officer of the legislature, independent from government, and receives complaints from state owners and adjudicates responses and issues reports, and there's a whole range of other things that I'm sure he'll talk about. But over and above that, he's a political scientist. Yes. He had his BA from Memorial, correct, and an MA from Queen's, and then went into government and had a variety of responsibilities in government, one of which was involved with the Canada Health Info Way, establishing the security and privacy rules regarding the sharing of personal health information across Canada. So he's eminently qualified for this job, but he also has I think I prefer to say, a larger perspective on the issues that he's responsible for enforcing. Because as a political scientist and a social scientist, he thinks critically about democracy and rights and liberty, etc. And therefore, he thinks about those things in larger terms. So I thought he'd be an ideal speaker for this group. And with that, I'll hand it over to Michael Harvey.
Thank you very much for that. So before I begin my remarks, I'd also like to, as you did, and I appreciate that you did, Oliver, like to respectfully acknowledge the traditional territories of the Lekwungen people of the Songhees and Esquimalt First Nations, where we gather today and where I am feel particularly privileged to live and work and play. And as an officer of the British Columbia Legislature, I also acknowledge that I'm privileged to work with Indigenous people across many traditional Indigenous territories, which cover all regions of our province. I really appreciate Colin's introduction. I very much appreciate this turnout today. I feel very honored on a day like today for you folks to be in here with me rather than somewhere outside, which is a very lovely place to be here in Victoria on the spring day. This kind of environment, as you can imagine from Colin's introduction, is one that I find myself quite comfortable in. I've always approached my career as I'd sometimes describe it as a political science. Or at least that's how I have tried to think about my career as it has unfolded. unlike many of my colleagues across the country, not all of them, but most of them tend to be lawyers. And so I tend to come at it from a slightly different perspective. It's really important that we have lawyers around our federal immigration territorial table, and certainly lots of lawyers work in the Office of the Information and Privacy Commissioner. But I try to bring that political science perspective to it, and the motivating question behind how I approach my work as commissioner here in BC and previous to that in Newfoundland and Labrador has been, to me, the real question of my career has been the interaction, the tensions and interdependency between liberalism and democracy, and our rights as free, autonomous, and dignified individuals. And how do we reconcile that with our need to collectively govern each other? That's really been the question that has motivated my career from where I started in intergovernmental affairs in Newfoundland and Labrador through to my work in the cabinet office there for some years. And then out into line departments. I worked in Child, Youth and Family Services for a period, but a slightly longer period in the Department of Health. And I didn't ever intend to end up in the information and privacy circles. I found most of the people in my professional sphere now are lifetime information and privacy people. But for me, this is a career that I kind of wandered into. But it's a perfect fit for me because of that, because it's right there at that nexus between individual rights and democracy, and particularly now as we move into as we continue our move, and we're still in the early phases, the first generation of the information society, the information economy. And so I could think of no better career to have kind of stumbled into. I find it motivating every day for those reasons. So I'm going to take a little bit of time, because this is such a diverse group, to talk a little bit more about what Colin introduced, which is the statutory framework that governs the OIPC and the ORL. The OIPC, I'll try to avoid too many acronyms. The OIPC is the Office of the Information and Privacy Commissioner, and the Office of the Registrar of Lobbyists. Those are two offices, two different statutory mandates. As Information and Privacy Commissioner, I have a mandate under FIPPA, the Freedom of Information and Protection of Privacy Act, as Colin mentioned, and also PIPA, the Personal Information Protection Act. And also I have a mandate under the Lobbyist Transparency Act, the LTA, and it's a separate office, but it's co-located with the OIPC, and we have overlapping staff. It is an entirely separate mandate, but there is a thematic connection, in my view, between the two offices, and the thematic connection, in my view, is transparency, which is one of the main themes that I'm going to talk about today, as well as rights. So under those two acts, I'm appointed as a statutory officer of the Legislative Assembly. And so I want to spend a bit of time talking about what that is in the Canadian system and why it's important. So I'm not a member of the executive branch. As I mentioned, I spent most of my career as a member of the executive branch, but I'm a member of the legislative branch. I was appointed by the legislature here in British Columbia itself. I'm one of 9. For those of you who may not be intimately familiar with our provincial government here, our system of government, there are 9 independent statutory officers. Every province and the federal level has officers of the legislature as part of the legislative branch that are appointed and operate independently. They are subject, like I am, subject to administrative oversight from the legislature, but are politically independent even from the legislature itself within the scope of our terms. So yesterday, I had the big event in the life of the stat officer. I went before my legislative committee and asked them for money. That's the most important thing, that most important relationship that I have with them, that they give me money. And then after they give me my authority, which they did at this point roughly last year, they need to give me the money that I can do. But once they do, I'm generally independent, other than I have to provide an annual report and of course stick within the law. So to follow my mandate. So what is that mandate? So in British Columbia, I have on the information and privacy side, my mandates for the public sector, as Colin mentioned, from FIPA, and that governs the freedom of information side, and it governs privacy. So on freedom of information, anyone in British Columbia, anyone at all, you don't even have to be in British Columbia, has the ability to submit a request for information. I expect that most of you are familiar with this concept. You submit what we call an FOI request, and the default under FIPA is that you have access to information that is in the custody or control of core government or these other public bodies that Colin mentioned. If you don't get, the default is that you have the ability to access that information, but there are many different exceptions to that right of access that generally provide the ability of government to do its work. Things like protections for policy advice, to protect the ability of policy advisors for government to give free, candid advice without fear of it being exposed and then second guessed. Things like cabinet confidences, legal confidences, and of course the privacy of other individuals. And so you can submit an FOI request. It may, the default is you have a right to that information, but some of it may be held back in whole or in part for those exceptions. If you have a problem there, then what you first should do is take it up with the public body, but after that, you can come with it to our office. And we can look at what has been held back from you and determine if it has been held back legitimately. And so that is one of the core things that my office does, is that's called a request for review. You can also submit a complaint about what you have received back. These are slightly different. Both of them will be investigated. 90% of the files that come into our office are closed at either intake or investigation, as they're handled essentially informally. The rest of them will go to adjudication. And adjudication is when the particularly complex files get handed over, and at that point they are treated. Our adjudicators are legally trained, and they do a very careful analysis to determine what legal rights are. This same process is used for privacy complaints. So if you believe that your personal information has not been appropriately handled by a public body, similarly, first we tell you to go to that public body and make complaints. But if you're still not satisfied, you can come to us and it will be investigated, and we'll come all the way through that process until it has been resolved. One thing that's particularly special about British Columbia is that we have, in this province under FIPA, we have order-making power. And that means that the adjudicators, so they're in my office, there's 11 of them, and they operate on the basis of delegated authority from me. Our adjudicators can make orders that carry the force of law and are subject then to judicial review. And so this office has considerable teeth. The office that I came from in Newfoundland and Labrador did not have quite the same amount of legal strength. So there's a strong mandate under FIPA. As for PIPA, there's an even broader mandate. So PIPA, under PIPA, is the act which provides private sector privacy authority. I'll say a little bit about how the legal framework works in Canada. The federal government has an act called the Personal Information Protection and Electronic Documents Act, PIPA, PETA, depending on how you say it. So the federal government has jurisdiction, but the provinces can, if they pass laws that are deemed to be substantially similar to PIPA, they can essentially chase this jurisdiction. And this is what we have done here in British Columbia. We celebrated the 20th anniversary of PIPA last year. So British Columbia has moved into this space and has passed legislation that provides provincial level privacy oversight. And so our oversight is also it's actually even stronger than at the federal level. Under PIPA, my federal colleague, the Office of the Privacy Commissioner, has what we call ombuds power, or the power to make recommendations. Where here we have order making power in British Columbia. This is also true for Alberta and Quebec, but not the other provinces. But British Columbia has a high degree of provincial level privacy protection that the people of British Columbia enjoy. But it's also even broader than that. British Columbia's PIPA covers sectors that no other province in the country covers. PIPA covers private sector for-profit businesses, but also not-for-profits, charities, churches, political parties, and even or at least as has been found at by the courts, but subject to further judicial review of this question. Our law even covers federal political parties, but maybe this is something that Colin, who has an interest in this matter, can talk to you on a separate occasion because the matter is before the courts. But I'll leave that to him. But the moral of this story is in British Columbia, we have the broadest information and privacy mandate to provide those protections to British Columbians. I should also say, and I won't talk much more about lobbying transparency today, but British Columbia also has the leading law in lobbyist transparency. We have, under the Lobbyist Transparency Act, if anyone is lobbying any public office holder, they are, and it's part of their job to do it, they need to register as a lobbyist, and then they need to report their lobbying activity in a manner that is then made available to anyone to see in a public registry. And if they don't, that is subject to investigation by my office. And not only do those investigations have the potential for order-making power, but also my office has the ability to assess administrative monetary penalties. Which is a power that we don't even have under PIPA. So this is the strongest level of lobbying transparency protection in the country, and is one of the leading acts internationally. So this is really what made it very attractive for me to come to British Columbia, as well as the other many attractions that British Columbia has. But the scope of the mandate is extremely broad. I've spent time talking about this because I think it's very important to understand the importance that a statutory officer plays in a modern system of governance. Because I think it is not widely appreciated, even by many people within government, the importance in a complex modern democracy that statutory officers play. Our democracy, as all of you will know from your own areas of expertise, is increasingly complex. And even though, as we recently witnessed in October here provincially, and we'll witness in just a few days federally, our democratic control that whereby legislatures get elected and hold executive branches accountable on a day-to-day basis. Ensuring the accountability of the executive branch is something that can't just be left for every 4 years or so. It also can't be left to legislatures alone to be trying to do in question period. And so legislatures have established these statutory officers to provide more day-to-day ombuds. And we, I think, are really important in trying to provide that accountability and to and so the British Columbians can feel that that their government, there's accountability mechanisms in place, and that they can know that if they have a need for recourse, then there's somebody that they can go to. If that need for recourse is in the area of access to information or privacy or lobbying transparency, they come to me. If they feel that they've been treated unfairly by a government department or a public body, they can go to my colleague, the ombudsperson, and so on down the list, from the Human Rights Commissioner to the representative for children and youth. There's a number of different ways where this complex oversight is provided. And I think this is all the more important now because I think that we are facing in our society and globally a nadir of trust. And you know, I happen to think that here in British Columbia, where I wouldn't want to be in any other place, when I look internationally, but also elsewhere across this country, I feel that that the trust situation is worse, but we are in no way we do not enjoy the luxury of being able to pretend that this problem does not exist here in British Columbia either. And we also need to ensure that our society, the fabric of our society is resilient for further challenges. These, in my view, this is a long-term thing. Political scientists have been studying decline in trust for a generation. And there are a number of factors, I think, that are in play that have exacerbated the situation and brought it to really a crisis point. I'm not sure if many of you follow the writing of Paul Wells. Paul Wells, a commentator on Canadian politics, wrote a really interesting column the other day that cited a Policy Horizons Canada report his column was about the Pierre Colbert was commenting on this Policy Horizons Canada report, but Colbert didn't talk about this particular part, but the part that Wells talked about was a crisis of certainty was highlighted in this. The crisis of certainty was where people don't know what to believe anymore. There's a lack in an understanding of what is true and what is not. I think that in my little piece of the mandate, the lack of faith in what is being done with information about us, a lack of trust in what our elites and institutions are telling us, and whether it's true or not. And this contributes to an erosion of trust at the interpersonal level and all the way up through to the institutional level. And when that trust crisis metastasizes at the institutional level, then I think we're in big trouble. So this is the kind of thing that my colleagues as statutory officers talk with each other about. We have agreed that this is a challenge that we all face, but that this is a role also that we all play, and our independence, our real and perceived political independence, is the lever that we have to pull on to try to protect and restore trust in institutions in Australia. And I think that at this moment we need to pull every lever that we can to protect trust in our society. And that's a theme that I'll return to as I continue to talk about privacy and trust. And so I'm going to pivot now and start to talk a little bit more about privacy and identify some of the trends that we've been seeing globally, nationally, and locally. The first one that I want to talk about, and I referenced this earlier when I talked about how we are in the first generation of the move into the information society. Increasingly, and this is a word that I wasn't using in the same way, but that Wendy Wong out of UBCO was using and uses in her excellent book called We the Data, which I highly recommend if you're interested in the stuff that you read. And she used this at a talk the other day, uses it in her book, Datafication of our Society. Also, if you're familiar with the work of Susanna Zussman out of Harvard, she's excellent work on the surveillance society. Everywhere we go, increasingly, we generate data. Our world is increasingly digitized. One of the things I always say in my remarks is that a number of years ago we talked about the metaverse, and so much so that Facebook changed its name to Meta, and everybody was excited about the metaverse, imagining this virtual society and that we would live in and we would have digital avatars, and we would spend some of our time going around and interacting with each other in this virtual society. Nobody really talks about that in the same way anymore. And I think the reason why is because they don't need to. We are our own avatars. We are living. Our society is now thoroughly digitized, and we are interacting in our virtual society when we're here today. I mean, all of you, I think right as I sit here now, on my person, I have 4 connected devices, one of which is inside of me, right? It's a but it's now maybe more than it's what that was. It's but it too now is connected, right? And so I generally, I wear a watch, I don't usually wear it, my normal analog watch in the shop, but I usually just wear this thing when I'm exercising, but I gotta tell the time. But we generate data. So from my watch to multiple phones to the iPad that's in the bag to this thing that's in my chest, all of it connected, all of it generating data. My physicians now, we used to talk about virtual health back when I was in the Department of Health, and we talked about virtual health. It was a thing that was used as a substitute for in-person healthcare if you couldn't get in-person healthcare. So it was mainly telehealth was for remote environments. Now, virtual health is mainstream. When I had this thing put in, my physicians would get data from it once a year, once every 6 months when I go in to see them. Now they get data from it every night by a device that sits there on my bedside table. So we're generating this data everywhere we go with everything we do, and there's vast masses of it around. And this data, it has economic value, and it is being used for our benefit and for the benefit of others. And this means that what happens to this data, all of this is personal information, and what happens to it and the way that it shapes our economy and society is fundamentally a privacy question. And so this means that the privacy discourse among regulators, and I would expect in as well, has changed. Privacy, when these laws were first passed, was conceived as largely a security question. Is your data being held securely in a place so that unauthorized actors can't get access to it? Now the privacy discourse is much broader, and we think about privacy as how do you control the information about yourself? And in this sense, in the information economy, if the information about us is everything, right? If that is the nature of our economy and our society, is our personal information, then our ability to access and control that information is everything. It is our destiny. It is, and I mean, there's there's arguments that it always has been, but the change in technology has made this question more acute, right? It is certainly the personal information about ourselves and how it gets into the hands and interpreted by other individuals is the precise nexus at which we as individuals enter our society. So therefore, by that logic, then our information and our right to privacy is, and this is something else that we've been talking about it for a long time, but I think Professor Wong in her book that I said earlier did a great job of really explicating how privacy is a fundamental human right. Legally speaking, the courts in this country have grounded privacy as a right in the charter and connected to primarily section 8 of the charter, which is unreasonable search and seizure. However, I think those of us increasingly in these circles are starting to understand it as a fundamental human right, or I even argue as a proto right, as a right that underlies our other rights. How can we enjoy democratic rights if we cannot, and how can we exercise those democratic rights and the other political rights if we cannot have a sense of individual privacy and control over our individuals? It is fundamental to us as free, autonomous, and dignified individuals. So I think that this is the fundamental concept that I think is important for us to recognize for moving into the information economy. And I'm going to come back to why I think it's important to keep that in mind when it comes to legal reform and moving forward. In British Columbia today, so when I came, I'm going to change tack here a little bit. When I came to British Columbia, I thought that certainly coming from Newfoundland, which is the first place in Canada to be settled by Europeans, and it is an old society. Come to British Columbia, one of the last, and a very, in some ways, except for the civilizations that were established by our First Nations, in many senses, still a very young society, and a very future-oriented and Western-looking society. Western, by which I mean across the Pacific and to Asia, to the Asia Pacific, and Southern-looking society. I kind of expected to be moving to the future, and that the concerns and the privacy concerns that I'd be dealing with on a day-to-day basis would be really future-oriented. British Columbia has a very vibrant tech sector, and I thought that that's what would be really dominating the conversation here. And it is in many respects. So some of the most important investigations that my office is doing are into the kind of the bleeding edge tech stuff. So we have big investigations ongoing now with TikTok, or into TikTok and into OpenAI, the company that operates ChatGPT. So I encourage you to keep your eye out for the coming number of months. We'll be issuing reports on those two companies. We're doing those investigations with our federal colleagues and those in Quebec and Alberta, as well as a collaborative investigation. But on a day-to-day basis, what we hear about a lot are really the mundane issues. I joke sometimes that these are the hot privacy topics on the agendas at privacy conferences 20 years ago. And by which I mean the hottest topic that I'm dealing with now is video surveillance. And I thought that this was like old hat by now. Video surveillance, cameras. We're still talking about cameras, but we're in British Columbia. We're talking about cameras a lot. I have numerous active ongoing files related to multiple municipalities wanting to set up cameras. All of you live here, you know that people are concerned about crime and disorder in communities, and it seems like the reaction is to put cameras up. So cameras are going to solve all of these problems. It's not entirely clear to me how the camera is going to solve all the problems, but people really like their cameras and feel secure. But it raises really significant privacy questions when municipalities start putting up cameras everywhere. And now many of these, I'll give you some examples. So this was in the news recently, so well in the public domain, and I commented on in the public domain. A lot of stuff I can't comment on because these are active ongoing investigations, but in this particular case, it's certainly the discussion is well in the public domain. So the city of Vancouver has set up a series of traffic cameras all around. Anyone who's been in Vancouver knows that there's traffic cameras everywhere, red light cameras, speed cameras, and so on. These are low resolution cameras, whether they're used for traffic enforcement, or sometimes they're used for just traffic monitoring, to monitor traffic levels and provide feedback on, it's busy on, see a sky and so on, to feed that information back or provide that information to motorists. And sometimes they're used for traffic enforcement, which is within the legal jurisdiction of the municipality. But recently, Vancouver City Council decided that it wanted to change these cameras to provide access to them for law enforcement. Well, that's not what those cameras were put up there for. Criminal law enforcement is quite different and it's quite different, but also quite different from a legal perspective than traffic law enforcement. The criminal law enforcement is the preserve of police forces, which are independent which are subject to civilian oversight, but independent from civilian control. All of a sudden, a municipality wanting to take cameras that were put up and justified for one thing and turn them into something else, that's a problem. But it's not a necessarily unsoluble problem from a legal perspective. And so that's not even what troubled me most about this whole episode. What troubled me most was when, in speaking to this, a Vancouver city councillor said, well, nobody these are cameras that are in public, and people don't have a reasonable expectation of privacy in public anyway. This is a very troubling idea for me to say that, because I think that this is a dangerous and insidious idea that people do not have, when in public, any reasonable expectation of privacy. I think that saying that fundamentally undermines the kind of society that we are. Like, if we have no reasonable expectation of privacy when we're going about our business, whether that is on a sidewalk, whether it's in a public park, whether it's in a business while we're shopping, or in a public building that is open to the public, to say that we have no reasonable expectation of privacy is a very dangerous idea. Clearly, our expectations of privacy are going to be different in different contexts. The way that I can expect my privacy to be protected in my own house or my home is different than it's going to be in a business. And in turn, that's going to be different than it would be on a sidewalk. Yes, there's going to be differences in reasonable expectations of privacy, but to have no reasonable expectation of privacy in public means that when you step into the public realm, you relinquish those protections you have over the information about yourself. And everybody is free to just scoop up whatever information that they might have about themselves. And if you match that with what I was saying before about how we are in this datafied world generating vast amounts of data, that becomes a very, very troubling idea. And the most troubling thing about that idea is how intuitive it is how people, aside from people like me who, hear city councilors say that and get all excited and outraged, I think many people, when they hear that idea, are like, yeah, I guess so. That sounds about right. Isn't that what public means? That's troubling when that idea starts to become accepted. It's troubling on a whole bunch of different levels. One of the ways that it's troubling is also that the notion of what we understand about each other and how we expect each other to behave. So when I'm going about my business in society, do I expect that you are going to behave in a civil and law-abiding way because someone is watching you, or because it's good to behave that way? And when you and our young people are being socialized in a society, why do they understand that it is appropriate to be, decent and law-abiding and civil with each other? Is it because that's right? Is it because it's right and moral to behave in such a way, or is it out of the fear of being fined? And this is, sociologists talk about blame-based society and shame-based societies. What are we as a society? So this proliferation of surveillance, physical surveillance, is problematic to me for a whole bunch of legal reasons, but also for sociological reasons as well, because of what it says about what we are as a society, and why we think that the British Columbia of the present and the future is going to be a civil society. Do we think it's going to be in that way because British Columbia has a healthy social fabric, or because of the fear of penalties? So this is how these things get become real. But this is when we talk about cameras, even though that was a hot topic of 5 years ago or 20 years ago, they become all that much more real with our online world, because our online reality is now the new public. The way that we interact with each other is on the sidewalk, in a store, in this room, in a university, but we are also present online. And sometimes we are present online when we're also in those other places. I think I'm probably present online right now. And we are also generating vast amounts of data. This becomes all that much more important in a world of AI. So Colin is waving his 5 minutes at me. I'm going to pretend I didn't see it, but I'm going to push through. Just a suggestion. I have a couple more key points I want to make in my argument here. So the first one is, in an AI world, AI applications are fundamentally different than traditional computing, because AI, what we're now calling AI anyway, which I don't think is particularly important. I think I would, if it were up to me, I wouldn't call it artificial intelligence. I would call it probabilistic computing, because this is what these AI cases are. Is they're based on really massive applications of statistical analysis in order to predict proper outcomes and the future. And for them to work better, they need to rely on massive amounts of data collection. I mean, I expect you all know this. Everybody's talking about this all the time. But what it means in the context of the need of AI applications to work and the dramatic datafication of our society is, you've got all of these actors out there. We're on the supply side, we're generating vast amounts of data, and on the demand side, there's organizations and public bodies just dying to scoop it up because they need it to feed their machines. This data is raw meat, and so as we operate, whether it's in the physical world, in the digital world, it doesn't even matter to talk about it. It's a false dichotomy now. We're generating all of this data. We're generating it into an environment where there's real hunger to just suck it up and use it for all these purposes. So what does this mean for legal reform? Increasingly, the trend is for legal reform to say that our privacy laws don't work anymore. And in many respects, they don't. Our privacy law, HIPAA, which I was talking about before, like PIPEDA, is a consent-based law. And that means that if an organization with limited exceptions, if an organization wants to use your data, then they need to get your consent to use it. And there are, again, relatively limited exceptions, and then there's distinctions between express consent and implied consent and so on, but it's still a consent-based law. The idea is that consent is how you exercise your right over the data. So consent is a fundamentally rights-based concept. Is consent feasible in this new environment where we're generating so much data and there's such demand for it? Is it feasible for the companies that need it to innovate? I'm not saying that the need is fundamentally illegitimate. It's not. And it can be quite legitimate, and the innovation can be quite legitimate. But is it feasible for that to be based on consent? Moreover, is it even feasible or reasonable to expect us to consent to the use of all of this information? Is it even fair to be putting that all on our shoulders to say, okay, it's up to you. We'll give you some tools to protect your personal information, but it's up to you to actually do it and to actually make sure that you consent every time. I know that because you live in the world just like I do, you do not read all of those consent notices and all of those privacy policies that you see every single day when you go to every single website. You don't do it. Nobody does. It's not possible. That consent model does not work anymore. But then, so what do we do in this environment? What do we do about this? How do we protect our rights at the same time as we recognize the realities and the responsibilities of this new world? Well, my argument is we need to go back to first principles and design a law that starts from rights and starts from consent, and find ways to repair the consent model where it has been broken, but also recognize that there are legitimate exceptions to the consent model, but not alternatives. I think it's really important that they be understood as not alternatives to the consent model, but exceptions to the consent model. The thing about a right is it's fundamental. It comes first. Okay, and this has been recognized by the courts that yes, companies may have legitimate needs for data, but the rights come first. So the need only should be considered after the right. And so where you build in exceptions to consent, they should also be understood as not, the organizations are not then freed from their obligations to obtain consent, but rather take on the obligations, take on the responsibility, and we need to put the appropriate guardrails in place. So this is, I think, I would argue, this is what I'm arguing to be a BC approach to consent that is needed in our reform of PIPA. I think it did actually reflect the PIPA reform that had been before the House of Commons, before this election was called, and it died on the order paper. Actually, before Trudeau prorogued the House, and it died on the order paper. Bill C-27 was the long-awaited PIPA reform that did, for the most part, encapsulate this approach to legal reform. But of course, it is now gone. My argument has been, my advocacy to the government of British Columbia has been, we've been waiting a long time for this. We need to move forward now in British Columbia to reform our law. If we continue waiting for PIPA reform at the federal level, we could wait forever. So that's where I'll conclude. My main pitch, my call is that I think it is consistent with Canadian values as entrenched in our Constitution, as reflected in our society, that we take a rights-based approach to privacy protection, and that we use that as our touchstone in guiding the necessary legal reform so that we can have actually effective privacy protection for the information society that we are already moved into. So I'll conclude there.
Thank you, Mark.
Thank you very much, Michael, walking us through the complexities of
accountability and transparency with respect to data. Greatly appreciate you taking the time to, now you can see also why Colin introduced you as a political scientist. You know, I think you've got all the passion for the issue and its political and social implications very clearly to the table. So thank you very much for this. We'd like to start us off. Oh, well, so let's go from left to right. That's why okay, for sure.
Yeah, thank you so much for the great talk. Really, really interesting. I wanted to ask about your discussion with the cameras in Vancouver about this reasonable expectation of privacy. And given your sort of like your rights first approach, I wonder how much does this reasonable expectation should it matter in your view? And what motivates my question, because I sort of think maybe you just might not care about what our reasonable expectations are. And what motivates my question is twofold. One, that other rights don't generally work based on what we reasonably expect to happen. My right not to get robbed seems irrelevant whether or not I can reasonably expect to get robbed. If I run through a particularly dangerous part of Winnipeg with $500 in my hand, I have a right not to get robbed regardless, even if I can reasonably expect I will be robbed. And the other thing that motivates it is that it seems like in that case, the city of Vancouver can change what's reasonably expected. Say they implement cameras for 100 years, and then in 100 years, I say, is it reasonable for me to expect privacy in public? No, it's not reasonable because for the last 100 years I've had cameras. So I know that was where your interlocutor that was discussing this reasonable expectation of privacy, but do you think, you know, our rights are just, you know, it doesn't matter what we reasonably expect. We have these rights regardless.
Yeah, that's why I think that this is why this has been an animating question for my career, right? Is because this is I think the privacy understood is a little different because it sits at that nexus between how we are individuals, but also members of a collectively governed society, right? And so every one of these situations does need to be assessed on a specific fact circumstance. And so it is in one sense fundamental, but it is not, our right to privacy is not absolute. Now in Canada, none of our rights are absolute, right? Section 1 of the Charter is that all of the rights in the Charter are subject to our ability to live in a democratic society, right? So I mean that's how this in Canada, that's how this conversation starts, right? So that's a powerful message in itself. But the reasonable person test, which is a kind of a legal, the reasonable person is a legal construct that doesn't actually exist. So there's really interesting ruling out of the Federal Court of Appeal on Facebook, where it was Facebook versus the Privacy Commission of Canada. We were involved, the OIPC was involved in this investigation, but we were not involved in this particular court case for kind of legal reasons that are kind of beside the point. But the interesting thing about the assessment of the reasonable person test was that Facebook had argued in that case that the Privacy Commission of Canada didn't like interview people about what their expectations of privacy were to assess what was reasonable and what was not. And the judge in the case, the Federal Court of Appeal actually determined that no, that's not how the development of the reasonable person test works. It is a legal construct that is created, and so you don't collect that person. You develop the concept legally based on the facts of the law of the circumstances. But you're right. Like this is something that is going to change over time as norms in society evolve, and this is why I think that our discussion about it is so acutely necessary. Because what is reasonable in 5 years' time, in a time when a different level of surveillance has been normalized, might not be deemed, even in this legal construct, to be reasonable now. And so that's why our rights can practically, but also legally, in a sense, slip away unless we're vigilant about them. Now, Vancouver can't just decide to put up these cameras. The legal basis under every personal collection of personal information needs to be legally authorized. No organization or public body can just collect personal information willy-nilly. There needs to be a legal authorization to do it. And Vancouver can't just do it for the purposes of the criminal law enforcement. Right? That assessment needs to be carefully done on what legal authority they have. But that is probably something, because it's subject to ongoing investigations, I should talk about.
Really interesting. Thank you so much.
And Max, yeah, that was the first, fourth person.
Okay, great.
Okay.
Thank you so much. Yeah, I'm positively overwhelmed by your insight. So I may have one reflection and one question. In terms of Facebook and some other social media platforms, I clearly see the paradox there. When you start with the idea of social media, we see that people would love to share about their personal life, but now they go strive for privacy. I don't know what is the boundary, we can think about it, but come back to your point that we have the right to exert our privacy. But think even before that, we have the right to decide whether we engage in that work or not. So it's just a personal decision right now. Then I certainly agree with Andrew when, like, a couple of years ago, like even again, I tried to take photos, particularly in the public places, and no one gonna say anything about that. You grab the camera, you can take photos in the public places. It is taken for granted. You have the right to take photos. And on the other side of the table, people in your terms, they have different expectations about privacy, particularly in public places. And I see that it's the same thing happen right now. But you put the terms, the argument that we need to have different legal model in the AI world, to put the guardrails, to have some exceptional condition or something. I would love to hear more how you elaborate on that, how it's going to be different in those
So I'll respond to a number of the different points that you made. The first one is I want to reflect on back in the fall of the year, I was invited to appear before the Alberta legislature that was doing a statutory review of their Information Protection Act. And one of the legislators, he said, these days, every, and we were talking the conversation was specifically about the privacy rights of children and youth, and we were talking about online. And so this legislator said, listen, every young person that I know wants to put all of their information online, and they want everyone to get it. And in fact, they want it to be discovered so that other people will share it around, and maybe they can even hit the jackpot and become an influencer. And then they will get academic, they'll get all sorts of wonderful attention and dopamine and even money from this experience. But that's not actually how we find that young people are behaving these days. I'll talk about my own experience. So I've got two teenagers, and when they were younger, I had an Instagram account. Back then, Instagram was not what it is now. Instagram was a thing where people would take pictures of their friends and family and share them with their friends and family. Now it's something completely different altogether. No one does that anymore. But at a certain point, it changed. And my kids were very aware of how it was changing. And so at a certain point, they said, Dad, don't take my picture anymore. Don't do that. Don't post that. What we find that young people are doing increasingly is carefully curating that info, their online persona. They don't believe that privacy is dead. In fact, they're very mindful of how of what they're doing with their personal information. So my daughter, for example, and my daughter knows that I talk about her in these kind of settings all the time. So I have her consent. But she, when she, on her Instagram account, she's just like almost any other teenager that's out there. They use their stories. The stories are transient to put day-to-day images up there. But then as for their, I don't know what they call it, their main account, where you've got, I guess, it's like a tile, pictures that are there all the time. What is it called? Your feed, yeah. But so the pictures that are there permanently, very few pictures are there. So this is not what Instagram looked like a while ago. You probably know this better than me, but this is not what Instagram looked like a while ago. Now they would have only a small number of, or even a couple of very carefully selected pictures that are there permanently, and then other ones that they carefully select for this more transient type of display. They will use Instagram for one thing, they will use Snapchat for another thing, they will use TikTok for another thing. They are very, very mindful of controlling their personal information. They are not necessarily, however, very good at it. They're not doing it right, and they're not doing it in a safe environment, right? So they think that they're good. Anyone who's had teenagers knows, one, they're very smart, and two, they're nowhere near as smart as they think they are. Anyone who's been a teenager knows. So so this is where I want to segue to the second, my answer to your second question is what does that look, what does regulation of this look like in the new
Yeah,
this new
you
division?
use the term guardrail, right? Guardrail. You use the term guardrail.
Guardrails,
Yeah.
yeah.
Guardrail.
So, I mean, I think that, so when we talk about, there's different guardrails for different situations. But I think that for AI, I think one of the things we need to, the principles that we would need to establish for AI are primarily, you need to ensure transparency, right? So there needs to be a transparency into the algorithm, which is really hard because the algorithms are inherently not transparent. But we need to hold, and some of these, I'm saying, these are standards that will be very hard to adhere to. But if we're going to have a safe society, then we need to figure this out, and we need to put it on companies to figure it out. How do we have algorithmic transparency? And this is really important for privacy, but it's really important also for fairness, things that are, and controlling bias, things that are not within my mandate as the privacy commissioner really to talk about, but are clearly important and mandate, let's say mandate adjacent. If algorithmic transparency is really important, it's, I think, going to be really important that we put guardrails around where the data comes from. So, you know, it is many AI applications now will scoop up data that is found in the web. So, you know, we often talk about the open web, which is accessible to anyone, and then the deep web, which is exists behind passport control. So most of social media is behind that kind of passport control. So many AI use cases have established their data sets by just scraping up that data. And we did an investigation of this, a very prominent one into Clearview AI. So this is a company. So now I'm going to come full circle to your original point to use the example of Clearview AI. So this was a company that developed facial recognition databases of billions of people. And it created these databases by scraping available images that were on the internet and matching them with each other. So you say, is it a reasonable expectation of privacy for someone to take a picture of you on a sidewalk if you're in public? Some people would think, well, you're in public, you know, you're in the background of my picture, then you know, you kind of give up your right to not have your picture taken. If you do want that picture taken, get out of the way and take that picture. But when you have a company like Clearview AI, which is able to scrape that data, you in the background of the picture, and match it with other pictures that are available from you online, and then take all that data and sell it to a police force that is able to then use that information to identify you and to identify your location. That application puts all of us, everyone in society, into a giant 24/7 police lineup. If that's not, that I think is a clear step beyond the kind into a surveillance society that I don't think is consistent with the values and this is what our office has found in our Clearview decision, and has been upheld by the courts. So I think that little circuitous way I would address most of your.
Yeah, I think we, we only need to talk
Yeah, then
more.
we come
Thank
to
you. Thank you, Mike.
Yeah.
Cool.
Thank you. Fascinating conversation. And I really like what you said at the beginning about the tension between democracy and liberalism. And I just want to be sure that I understand your main message about when you say the broad mandate of BC. Does that mean that BC generally has a tendency to uphold information disclosure and access to information through, the first part of your talk, or is it rather the mandate is to protect privacy and individuals and their rights? So that's kind of just to clarify my own understanding, but my real question is more about research and the role that you see for academia, because you say business needs access to this data to generate novel insights. And I would argue that researchers also might need access to data to generate novel insights. And we actually tried to do this in our lab, accessing import data on Canadian trade and commodities that are being imported. And we had a really hard time finding this data. And so I would love to hear your opinion on how a researcher, very uninformed, can go about understanding what information is even out there. Does this, like with regards to trade, for example, does this fall under the mandate of whether we can access that data? And then, is that something that you see coming across in terms of applications for FIPA or something? So, yeah.
Yeah, so I'll answer the first part of your question first. It's a discrete question about the breadth of the BC's mandate. So BC FIPA is the law that governs freedom of information in the public sector in British Columbia. It is an excellent law, is one of the leading laws in Canada in terms, and by which I mean excellent, I mean it is one of the I think that people can get access to more information in British Columbia than in many other jurisdictions. But it's not really an order of magnitude more than most. I mean, there are some jurisdictions in Canada that have more restrictive in the sense that the exceptions to what information people have a right to are broader. So there's some that have broader exceptions, so people can get less information, and there's some that have narrower ones, and people can get access to more. So BC is towards the more accessible side of the spectrum, but the strength of the system primarily lies in the strength of the oversight and our ability to use our order making power to provide reports to people who don't feel that they've gotten the information that they are entitled to. So that's where the strength of it. The breadth of, when I speak about the breadth of BC's mandate being broader than most jurisdictions, I would say that mainly applies to the kind of privacy side, and that there are more sectors covered. Okay. So with respect to your second question about the needs of researchers versus the needs of companies, I have dealt with that most in the health context. There's a very active debate on this in that sphere, and this goes back actually to my time working in the Department of Health. I was an ADM, and one of my responsibilities was I had responsibilities to both oversee the privacy legislation in that jurisdiction, but also had responsibilities to promote health research, among other. When you're ADM in a small province in the health department, you have many responsibilities, but those were two of them. Mm-hmm. And it was very common for me to hear from clinicians and from researchers and from commercial parties that all of them wanted to get access to this data and felt that they were they were stymied by getting access to it because of privacy. And our privacy regime was getting a bad rap because people who felt that they either were or should be legally authorized to get this data weren't getting access to it. That is a debate that is happening across this country. It is quite difficult to get access to health data, even for clinicians. Our health information system is highly fragmented and not very interoperable, even within provinces, let alone between them. And this creates real problems. It creates real problems for clinical care, and it creates real problems for research, and it creates problems for innovation. You know, when I moved to BC, I essentially had to abandon vast amounts of my health information. And so when I go in to meet some of my clinicians, I kind of have to do it from scratch, which really matters if you've got a complex disease. It matters quite a lot, and is you know, kind of preposterous in this day and age in Canada that I had to do that moving from one. It's also consistent with the Canadian Health Act. Where the research question comes in is researchers will commonly say, I want to get access to this data too, and I can't because of X, Y, and Z. And some of those reasons are not related to privacy, even though they're commonly blamed on privacy. They're commonly, the real issue is often data quality, the existence of the data at all, technical interoperability between the systems, and often it's that people don't even want, the people that are in possession of the data don't want to give it out, even if they are not actually the owners of the data, who are the individuals. But the discourse in the health sector is to try to push for, in a variety of different ways, to increase access to health data. And what I've been arguing for is to make sure that we do this in a way, we increase interoperability in a way that is consistent with the values that people have about their data. And I think in this country, people have kind of amorphous ideas about who should get access to their health data and for what. And so I have encouraged people to use, and I'm not the only one who does this, but I've encouraged people to refer to the concept of social license, which is a concept that's really found in the natural resource exploitation sector, but I think is useful in this context as well. To make sure, because social license is a more precise concept than just trust, because it refers to a process of this licensing process of going out there and trying to determine if people are okay with the use of data for this process or for this purpose, and then to maintain that sense of trust over a period of time, in the same way that a mining company would have to obtain and maintain social licensing over a period of time. So I think, and everyone believes that researchers should have greater access to personal health information for the public good. And people's feelings about how easily they should get access to it will vary depending on the use case. People will also have I think Canadians also have complicated feelings about health information when it relates to commercial information. You ask people up front, should private sector companies get access to your health information that they will then use to make a profit? Then people often say, no, they should definitely not get access to that. But private companies have always been at the heart of Canadian healthcare. And you know, if it wasn't for the use of personal information by big pharma, and we talk about big pharma often like we talk about big tobacco these days, but if it wasn't for big pharma, then where would our drugs come from? So these are complicated questions that all need to be assessed on a case-by-case situation. Now, as it applies to trade, it depends. I think a lot of the data as a trade researcher, and I mean, I'm not an expert in this area, so a lot of the data, I'm not sure whether it will be PI or not, personal information or not. It might not
It's
be.
more a corporation.
Yeah, so I think that is outside of my mandate, our sphere. I think that data is a separate thing.
Thank you very much for your excellent talk. I really enjoyed it. So how can we instigate and increase trust, because trust was one of your keywords in, because without trust wouldn't be any cohesion in the society, right? So in terms of the policy making.
Yeah, that's a great question. Because it's easy for me to sit up here and say, trust, you trust. But you know, how do you make that happen? Well, I mean, the first thing I'd say is make sure that that your regulators are and are perceived to be independent and have the resources so that people know that there is recourse. So that's, I'm sure you'll appreciate that. Of course, I'm going to say that given who I am. I have a self-interest in saying that, but I believe that I think the level of awareness in BC of our office is something that my predecessors did a great job at expanding, but I think there's a long way to go. So there's one. I think the second thing is that there needs to be more discourse. The way that we talk about personal information needs to change, and that means greater digital literacy in how the leaders of our political leaders, our policy leaders, but also other leaders in our society, including among the academic sector, talk about privacy. If people keep saying privacy is dead, then pretty soon that will become a self-fulfilling prophecy. But if our leaders of corporations, our academia, our political leaders have higher levels of data literacy and talk in more sophisticated ways about data, then I think that will really help. And then the final thing I'll point out is education in our schools and the socialization of our kids.
Makes sense, thank you.
All right, like I can see, we can keep you here for another hour or two, but let's maybe come to the last two questions and then we wrap up our 12. And also, Kelly, thank you for shedding light on the Tri-Council policy statement regarding humans as research subjects in health data and so forth. So there are agencies trying to find a good way forward in this. Yeah. Cornelia and then Colin. Cornelia, do you want to open your mic?
Hey, can you hear me?
Yes.
Okay, thank you for your presentation, which was very interesting. I'm a scientist, so I'm a bit outside the field here, but I have a question about, you advocated to a process which puts rights first and you go from there. So with the speed in which AI and the dissemination of information is changing, do we have enough the correct structures like your organization to actually implement such an approach, or are we just playing catch up?
Again, maybe I hand over to Colin for his question, and then you can wrap up with the final reflection.
Oh, okay. I wondered if you could just share some reflections on the moment that we're in right now in Canada. I've read the federal party platforms the last couple of days, and the word privacy doesn't appear in them. The word civil liberties doesn't appear in them. Artificial intelligence appears, but all in terms of promoting innovation, nothing about guardrails. The word rights appears, but it tends to be in terms of collective rights, Indigenous rights, its own. The word sovereignty appears a lot. So in this process where we maybe are not convinced decoupling from the United States economically, anybody thoughts about what that means for privacy and what that means for the protection of personal data in Canada? And I guess more specifically, I'm asking you about data residency requirements and data localization. Should we be thinking more about keeping our data here? Because we've had this experience in British Columbia. We had a provision in FOIPA which said exactly that. The data should not be stored outside Canada without individual consent. It didn't work too effectively. Anyway, any thoughts about that?
I mean, it was interesting. One of the conversations that Oliver and I had before when I first arrived here today was about, whether in the context of this potential decoupling, Canada, we've been talking about this debate that had begun about, can Canada become a member of the EU? And, my view on this question is that, there are models for, first of all, if we're going to imagine that the United States is going to, in 5 years' time, not be our most important trade partner, we're kidding ourselves. The entire structure of the country and our geography is based on our economic relationship with the United States. Pierre Trudeau talked about triangulation in the 1970s, and our integration has only gotten closer since then. We're kidding ourselves if we think that's going to happen. But that said, that's not to say that there aren't models by which we can and maybe we should become closer to the European Union. If not really to fundamentally decouple economically from the United States, but also to free ride a little bit on the European approach to regulating the economy. And in our particular area, the effect of the GDPR, the General Data Protection Regulation, which came into force in 2018, and is the global leading law when it comes to data protection. The effect of the GDPR has been internationally has been profound, because anybody who wants to do business with the EU that involving data transfers has to be and be at that higher level of trusted partners needs to meet these adequacy requirements. Canada has always found itself in between, kind of stuck in between an American model, which is kind of largely based on consent and notification, and really privacy in the United States is regulated differently than anywhere else in the world, primarily as a fair business practice. The main privacy regulator in the US is not a federal privacy regulator, but rather the Federal Trade Commission. And then the European model, which is a GDPR stronger regulator. I think there's scope for us to, while maintaining a rights first, consent first model, learn more and move closer to the European model of the GDPR. I think there's a lot we can learn about it, about how to repair our consent model while still developing a privacy model that makes sense for Canada. Now, as it relates to the specific question about data sovereignty, as you referenced, British Columbia was, kind of uniquely did have data sovereignty requirements that meant that data had to stay in BC at the time and got rid of them. And at the time that happened, I would have argued that the data sovereignty was a bit of old school thinking. I mean, so much of data when our data is traveling about now, it's going all over the place. And really, it'd be better to focus on cloud protections and on strong security and strong requirements for contracting and to ensure security in that way. But that was then, and this is now. And I think now that our southern partner may be becoming more unreliable at a rate that we did not foresee even a number of months ago, that there may be call for us to examine whether there are certain classes of data that are so sensitive that it may make sense to explore again whether data sovereignty requirements for certain classes of data may actually make sense.
Yeah. And with this, in a way, you address Cornelia's questions. Are we prepared, right, institutionally?
Yes. Yeah. So I think the answer to that is we are not prepared. The things that I think we need to catch up for sure. I think that, just speaking about my own regulatory authorities, I think that they're going to need to be broadened with respect to AI. I talked about things that are not currently within my mandate, but are mandate adjacent. I think that it will be appropriate to expand the role of the data privacy commissioner to be more akin to a data protection authority, to allow me to be able to talk about those things in my mandate, to allow me to bring those things into consideration, because increasingly they're going to become inseparable. I think that's in one respect. I think the other thing that I've been calling for more is the ability to assess administrative monetary penalties. I mentioned at the very beginning of our talk that I have that authority under the Lobbying Transparency Act, and I don't under PIPA. I think that to make these large companies stand up and take notice, modern regulators need administrative monetary penalties. Our colleagues in Quebec have just been given them under its new private sector privacy legislation there, and we're watching carefully to see how that evolves. But I think that this is the next and required step in British Columbia for us to provide protection that people in the province.
Thank you so much. I hope this has started a conversation, exchange. It's fascinating. Thank you for coming. I think you all agree that this was a fabulous talk about a complex and sometimes troubling issue that won't go away, and again, we will see more iterations of the challenges emerging from data protection perspective. Thank you very much.